Okay. Good morning, guys. I know that the room is a little empty, so I'm going to thank you in advance for bearing with me and your patience. My name is Sarah Belton, and I am an attorney with the California Attorney General's Office with the Department of Justice. And we have a very long title today, but the key thing to keep in mind is that we're going to be talking about guidance for K-12 schools in making sure that all of the students and their families are safe and secure, particularly as we respond to an increasing number of immigration issues. So here's what's going to happen this morning. We're going to do welcome and introductions. I'm going to tell you a little bit about the office. I'm going to talk about enrollment discrimination, which even in California continues to be a necessary point of discussion. We're going to talk about AB 699, which created the impetus, the requirement that we do this guidance and that schools adopt policies to implement it. We're going to dive deep into 5 important pieces relating to the guidance and model policies, including handling information, what to do if immigration enforcement authorities are on campus, the various types of documents that you should be aware of that are implicated in immigration proceedings, and some general other points. I'm going to talk about some other documents that may be useful to you and your colleagues. And then we'll do questions. I should mention, I have no idea how they are doing questions from the virtual sites.
I will be giving them.
But you should feel free to interrupt me at any point. Like I said, I'm a lawyer. We tend to be dense. This stuff is and can be complicated, make my brain hurt too, so feel free to ask questions at any time. Okay, so like I said, I'm with the California Department of Justice. We are a big office and do a lot of things. But what I would like to highlight for you is the work of the Civil Rights Enforcement Section. We are located in various offices around the state, and we do a lot of different work. And that has evolved over time. So what I will say is the bread and butter of our work is, addressing general civil rights issues, discrimination on the basis of any number of protected characteristics like race, religion, national origin, gender identity, sexual orientation, disability. We look at law enforcement and police practices. We have a special unit in the Civil Rights Enforcement Section that is devoted to workers' rights and focusing on issues related to the underground economy. And then we also focus on protecting some of our most vulnerable in children in the Bureau of Children's Justice, which is where my work is centered. As part of that, our work typically looks something like big civil systemic investigations, and when I mean civil, I mean not criminal. We do a lot of litigation, including recently in the past couple of years. We send out letters seeking information or documents or changes in practice. And we often negotiate corrective measures with targets of our investigations or work in stipulated judgments. With the change in the federal administration beginning in 2017, we've focused, our work has shifted a little bit into more litigation and into work dealing with immigration issues. So this is due to the federal government's, what we can say is an aggressive assault on certain populations and groups of people, and from their withdrawal and some of their previous work that they had done, leaving a gap or a vacuum that needed to be filled. So a couple of things that we've done recently that you might be aware of is, we led the charge to protect individuals who had deferred action for childhood arrivals, or DACA. That case is on appeal. We have joined with a number of states, 17 states and the District of Columbia, in challenging what became known as the federal government's family separation policy. That case is ongoing. We've defended our state laws, delineating sort of how state and local law enforcement agents should engage on immigration issues. We won that case recently, securing a lot of grant money, millions of dollars for the state. We've challenged the federal government's ability to impose immigration enforcement conditions on federal grant funds. So, you guys are here. I'm going to ask you, where are you from? What do you do?
I'm a math teacher at Santa Clara High School.
Okay. Do you?
I'm a state preschool teacher in Sunnyvale.
Okay. So I work out of our Oakland office. We're all sort of North Bay. I will assume that some of the virtual sites are not North Bay. But, you know, depending on what you do and the student populations you serve, you may interact with this in a variety of different ways. So this is just, you know, some general information. Okay. Like I said, we have to talk about enrollment discrimination. And this can look differently, but our guiding principle, right, is that schools are not permitted to ask invasive questions about immigration status. Schools are only allowed to ask questions necessary to obtain information about residency in the school's district service area, as opposed to legal residency or legal status, and information they need for statistical data that's required to be collected, like whether a child has attended school in another country. So some things to think about. In a previous life, I was a direct services attorney and I represented children. And part of my representation often was intended to make sure that children were able to enroll in school. And I will tell you, having to go to a district enrollment office, even districts that do this very well and it's smooth and streamlined, can be stressful for a student and their family. What are they going to be asked? What are they going to have to be provided? And then where are they going to be placed? So I will tell you that our office has engaged in discussions with over 100 school districts to correct materials that have asked impermissible questions or given the impression that students could be denied enrollment based on immigration status. So when I say this is a continuing issue, this is a now issue. This isn't a we're in California and this only happened decades ago. So it's just something to pay attention to because we want, again, in our country and in California, the right to a free primary and secondary education reaches all individuals and not only those who are citizens. Okay. AB 699. So it did two things. It requires the Attorney General's office, i.e. our office, to publish model policies limiting assistance with immigration enforcement at public schools to the fullest extent possible consistent with federal and state law, and ensuring that public schools remain safe and accessible to all California residents, regardless of immigration status. And it required, by July 1st, 2018, all local educational agencies in California, including school districts, county offices of education, and charter schools, to adopt these or equivalent policies. I'm not going to call you out or the virtual attendees out about whether or not you've seen your school district's policies and been trained on them, but hopefully this is more of a refresher than a first-time awareness. A couple of things to keep in mind about our student populations. In the preamble to this statute requiring these model policies and this guidance, the legislature found the following, that almost 1 in 3 Californians is foreign born, and 1 in 2 children has at least, in California, has at least one parent who is an immigrant. And the legislature also found that children are entitled, that a positive school climate is one in which students, educators, and staff feel safe, welcomed, and supported, and connected. So that's obviously just a principle in general, but especially applies to this population. Much of what I'm going to cover today is included in your handout. This document is some 50 pages. It's long, it's dense, so peruse whenever you have a chance. But it also notes in the beginning that There are approximately 250,000 undocumented children in California between the ages of 3 and 17, and that 750,000 K through 12 students in California have an undocumented parent. So there are a lot of students in our state who, whom this guidance may touch. Okay. So, Guidance Chapter 1, we're going to talk about gathering and handling student and family information. Schools have a lot of information about students. As you guys know, you're teachers, you see students every day, you interact with them. There are forms and various events that require family engagement and student engagement, and teachers talk to each other about students in their classes, and there's a central office, etc. So there are some sort of governing law principles that we're going to talk about, and then we'll get on to the policy recommendations. So the first thing I want to talk about is Social Security numbers, which for all the people that are adults who are listening in, we know that Social Security numbers are private. We probably are pretty diligent in protecting them and making sure that we're not, putting them out there. We don't, wear them across our shirts or our foreheads. So our state law actually bars school districts, county offices of education, and charter schools from collecting or soliciting Social Security numbers or the last 4 digits thereof from students or their parents or guardians, unless you're required to do so by state or federal law. So in general, we don't want to be asking for Social Security numbers unless there's a legal requirement to do so. From there, I will tell you that there is no federal or California law that requires schools to collect Social Security numbers from students or their parents or guardians for enrollment purposes. So for child to get into school, that's not a piece of information we need. We may need it later on for some reason, but it should not be necessary for the enrollment process. So we shouldn't ask for it, it shouldn't be a requirement, and if for some reason that is happening, we need to stop that practice. Okay, moving on to the next governing law piece, enrollment information. Our education code, section 48002, permits school districts to accept the following to prove age. We accept a lot of documents. A certified copy of a birth record or a birth certificate, a statement by the local registrar or county recorder certifying the date of birth, a baptism certificate, a passport, or when none of these documents are available, an affidavit of the parent, guardian, custodian, or other appropriate means of proving the child's age. So just like we don't want a Social Security number to be a barrier to enrollment, we don't want, birth age verifying documents to present a barrier. Similarly, a number of documents may be used to establish proof of residency, i.e. that a student and their family are actually residing within the district's boundaries. These include property tax payment receipts, a rental property contract, lease, or payment showing that you're making your monthly rental payments, pay stubs, voter registration, correspondence from a government agency, or a declaration of residency executed by the parent or legal guardian of the student. So again, we want to accept a lot of documents to show what age the student is so we can know where they should be placed, and to show that they are actually residing within the school district. School districts should never, and I do mean never, ask about the citizenship or immigration status of students or their parents or guardians for the purposes of establishing in-district residency. So we don't want to ask the question because we don't need it. It's not one of the 2 pieces that we talked about. Similarly, schools are never, and again I mean never, required under federal or state law to collect citizenship or immigration status information because it's not relevant to the enrollment process, so we shouldn't. We, in California, our state law specifically prohibits discrimination on the basis of an individual's immigration status for any program or activity conducted by a school or other educational institution that receives benefits from the state financially, or enrolls students that receive state financial aid. Local educational agencies may ask for, but parents are not required to provide, certain national origin related information. And here we're talking about students' place of birth. Were they born in a different country? On what date did they enter the United States? And the date they may have first attended school in our country, to comply with sort of federal or state reporting requirements for special programs, like reporting on language instruction programs for English learners. This information that school districts are permitted to ask for should not be used, particularly if a parent or guardian declines to provide it, to prevent children from enrolling in or attending school. Okay, so let's talk about policy informations about handling this information. So one, there should be policies and procedures for handling sensitive student information, and everybody working at the school should know those and should be trained on them. Other big policy recommendation is that local educational agencies should avoid seeking or collecting information regarding students or families' immigration status, i.e. we don't need it, so we don't want to ask for it. If a local educational agency is required to collect national origin information because of certain federal reporting requirements, we don't want to use that information to discriminate against children or their families or prevent them from enrolling in or attending school. We don't ever want to ask about information about a student's citizenship or immigration status specifically. And we want to collect any information that we need about a student's national origin, for whatever reason we need it, separately from the school enrollment process. And we want to explain when we're asking for that information. We want to explain why we're collecting it and if there is the parent or guardian's ability to decline to provide it. And then just this last point, lots of schools allow various individuals, adults, to volunteer and have certain processes that volunteers have to go through to get approved to be on campus and to be interacting with students. Local educational agencies should communicate to families about the available volunteer positions and whether those positions require completion of live scan or other fingerprinting. That should just be information that is disseminated generally, regardless to all families, regardless of immigration status, but is something that we want families to know what they're going to have to go through if they want to volunteer. Okay, moving on. All right, so we talked about gathering sensitive information. Now we're going to talk about sharing sensitive information. Okay. So like the last slide, first we're going to talk about governing law and then policy recommendations. Probably a lot of this is already going to be familiar to you guys because this is where we're going to talk about FERPA. So for citizenship and immigration status information, federal law does not impose an affirmative duty on state or local government entities to collect information about an individual's citizenship or immigration status. Our state law in California generally prohibits schools from inquiring into an individual's immigration status. We prohibit law enforcement from inquiring into that, and we also therefore prohibit school police departments under that law enforcement umbrella from asking. So, local educational agencies, therefore, that are seeking to protect immigrant students' privacy typically don't ask about facts surrounding citizenship and immigration status. And then if they're asked to share that information, they usually don't have any information to share because they haven't asked. Regarding personal information generally, typically, federal law requires that a school or a local educational agency has to ask for a parent or guardian's consent before releasing any student information to an outside entity. So that's the general rule or the general principle. Local educational agencies may release certain information without consent in limited circumstances, to certain enumerated individuals for, quote, legitimate educational interests, or if the release of information concerns only directory information. The Federal Educational Rights and Privacy Act, or FERPA, restricts local educational agencies from releasing certain private student information without parental consent or the consent of the student if that student is over 18 years old. We call those in our guidance eligible students. We have in the California Education Code overlapping protections and some additional protections against disclosure of students' educational records or other personally identifiable information, and school districts have to follow those. The school districts have to follow FERPA, and they have to follow our California state law. And again, in general, any written consent to share must be signed and dated by the parent or guardian or eligible student before the disclosure of the information. It must specify the records that are going to be disclosed, the purpose of the disclosure, and the party or like eligible class of parties to whom the disclosure is being made. There are certain exceptions to this requirement that you get written consent before sharing. These include, again, information relevant to the legitimate educational interests of the requester, directory information, and circumstances where the matter involves child abuse, neglect, dependency, or, again, this isn't very typical, but if the local educational agency is served with a subpoena, the subpoena prohibits disclosure, then you follow the court order or the request. Okay, we sort of talked a little bit about school police earlier. They are also generally restricted from sharing information. So the California Government Code prohibits school police from providing personal information about an individual for immigration enforcement purposes unless that information is publicly available. The definition of personal information incorporates information that identifies or describes the individual, including, but not limited to, physical description, what do they look like, their home address, their telephone number, their education, financial matters, medical history, and statements made by or attributed to that individual. So that's what we are talking about when we talk about personal information. School police cannot pass that over unless it's publicly available. So, although the government code does not prohibit school police from exchanging information regarding a person's citizenship or immigration status with governmental entities, FERPA's restrictions on sharing information contained in educational records apply to police employed by a local educational agency in the same way it applies to other educational officials. Okay, what are we saying? So, if you are associated with a local educational agency, you work for them, you are covered by FERPA. School police may have separate obligations under the government code about what they can share depending on what is publicly available. But school police have to follow that government code restriction, and they have to follow FERPA because they're employed by a local educational agency. Okay. There is an annual notification requirement, meaning that at the beginning of each school year, which already passed, so hopefully this happens as a matter of course in all of your school districts, we need to tell our students and our families what the policy is for student privacy, and how parents or legal guardians or eligible students can go about inspecting student information. In addition, at least once a year, local educational agencies have to notify parents or guardians if and when schools are going to release student information and the policies regarding the handling and the destruction of that information. If the policy changes for whatever reason during the course of the year, school board adjusts, etc., then you have to notify families again within like a reasonable time frame. Law doesn't say what reasonable is, but ideally soon. Okay, we talked about directory information. So this is basic student information that can be shared with outside parties unless a parent or guardian or eligible student opts out. There is no law that requires local educational agencies provide directory information. And directory information is actually it overlaps with some of the personal information we talked about school police not being able to turn over. So it can be important. Name, address, telephone number, date of birth, weight and height of athletic team members, email address, field of study, dates of attendance, participation in officially recognized activities and sports, and degrees and awards. All of that is directory information. It's a lot of information that could potentially just be turned over about students unless the family has previously opted out. Directory information cannot include citizenship or immigration status, national origin, or a social security number. So when we're providing the annual notice of the policies, we need to tell parents about directory information, tell families, and give them the right to refuse the release of directory information, the right to opt out. Notice has to do the following 4 things. It has to say the kind of information the school identified as directory information, probably something similar to that list that we talked about. Has to tell the family of the parent or eligible student's ability to refuse to designate that student's information as directory information that can be disclosed to outside entities. The period of time in which the parent or legal guardian or student has to opt out, and that opting out is the only way to prevent the release of the information. So, talking about policy recommendations, this is, again, private information about students and families that schools happen to have. We want to have a policy about how we're going to notify families when we get inquiries, when we get requests for information. We want to have a policy about what we're going to disclose when we get requests for information, including, and this is true at a lot of school districts, if you have families that are participating in programs that are specifically geared towards immigrant populations for whatever reason. And then we need to have policies requiring written consent from the parent or guardian or eligible student before we release information, unless that information is related to a legitimate educational interest or directory information. So, big picture, we want to know what the policies are, and we want to be sensitive, again, in what we ask for and in what we release. Okay, this is pretty dense and pretty heavy, so when we're going to be talking about some documents, thing to keep in mind is, in the world of federal immigration authorities, there are documents that they can issue that are administrative, meaning person who works for the agency can do it with the appropriate levels. And then there are documents that require some court approval, i.e. the signature of a magistrate or a U.S. District Court judge. Just keep that in mind. Okay. And hopefully a lot of this is going to sound familiar to you guys. Schools are what we call sensitive locations, meaning we typically should not be having immigration enforcement actions there. Both Immigrations and Customs Enforcement, or ICE, and Customs and Border Patrol, or CBP, have issued memos and accompanying frequently asked questions that describe policies regarding immigration enforcement practices at sensitive locations. Thing to note, these don't prohibit those types of actions, but they require that there be certain levels of approval or exigent circumstances, like it's an an enforcement action involving a national security matter or terrorism. There's an imminent risk of death, violence, or physical harm to person or property, or it involves like the immediate arrest or pursuit of a dangerous felon, or an imminent risk of destruction of evidence that is material to an ongoing criminal case. So only certain limited exceptions in those memos. These policies cover actions by ICE or CBP to apprehend, arrest, interview, search an individual, or to surveil, to collect information for immigration enforcement purposes. These policies do not extend to getting records or documents, other materials, providing notice, serving subpoenas, or just participating in official functions or other sort of community meetings. And CBP's policy in particular, which I know you guys are mostly from Northern California, but this may be relevant to some people participating virtually, do not apply to operations conducted near or at the international border, or that have sort of a nexus to the border. Other thing to just note, so we've spent a lot of time talking about these sensitive location policies. They're not law. They can be rescinded, modified, superseded, withdrawn at any time with little notice. Okay. We have state laws that provide that there should be policies limiting classroom interruptions. So school district boards and county office of education have been directed to adopt policies limiting classroom interruptions. And that means that one step below that, local educational agencies can also adopt policies that limit access to school sites, questioning of students for immigration enforcement purposes, because these activities or threats of these activities, thinking that ICE or CBP could just show up at any time, interfere with classroom learning. So moving on, when law enforcement agencies seek to enforce immigration laws, LEAs have to submit a report to the school's governing body if there's a receipt of a request for information or access for the purposes of enforcing immigration laws by law enforcement. And when again, we want to handle any such requests if they ever occur, to be mindful of the confidentiality or privacy of any potentially personal or identifying information. Our state law provides for notification to parents or guardians when students are contacted by law enforcement, except in cases of suspected child abuse, neglect, dependency matters. Schools, LEAs, are supposed to immediately notify parents or guardians if they release a student to a law enforcement officer, that would include an ICE officer, for the purposes of removing the student from the school premises. Again, except in cases of child abuse, neglect, or dependency matters, California law, our state law, does not prevent schools from notifying parents or guardians before law enforcement officers question a child at school. That's for any purpose, not just for immigration purposes. So our policy guidance specifies that LEAs should develop a policy requiring notification to parents or guardians before a law enforcement officer questions or removes a student for immigration enforcement purposes, except if that immigration or other officer has a judicial warrant or court order. Okay, now we're going to talk briefly about these various types of warrants, subpoenas, and court orders that can be used for immigration enforcement. First thing we're going to talk about is an ICE administrative warrant. It's a piece of paper. It's the most common type of warrant used by ICE. And in general, it can just be issued by any authorized immigration officer. It's not a warrant in the meaning of the Fourth Amendment. It hasn't come from a court. It's not supported by a showing of probable cause of a criminal offense. So an administrative warrant from ICE does not give any immigration officer special power to compel a school official to cooperate. So it doesn't for example, allow access to non-public areas of school grounds. And it doesn't just allow for a perusal in general or a search of school records. If it is not a court order, which it's not, that would permit a school under FERPA to disclose educational records for a student without consent of a parent or guardian or eligible student. So it follows then that if disclosure is made in response to an ICE administrative warrant, it could violate FERPA. So the other piece is that school police are generally prohibited from making or intentionally participating in arrests based on civil immigration matters. And again, if this happens, LEA personnel, school personnel shouldn't interfere or obstruct an immigration officer in the performance of his or her duties, but neither is an employee required to assist with the apprehension of a person identified in an ICE administrative warrant. And an LEA employee or a school official is not required to consent to immigration officers searching school facilities. Okay, the next document we're going to talk about is a federal court warrant. It's issued by a district judge from a federal court or magistrate. It's based on a finding of probable cause, and it authorizes search or seizure of property, typically with some particularity. The entry into a public place to arrest a person named in a warrant, or the arrest of that named person. So there are search and seizure warrants that basically permit an officer to go in and conduct a search that has been authorized in the warrant, in the document. And there's an arrest warrant that allows a federal official to arrest the individual that is named in the document, in the warrant. So if you ever get a warrant, if somebody comes and says, hey, I've got a warrant, right? Then school officials should act in accordance with the guidelines that have been established by the LEA, consult with legal counsel, and proceed accordingly. Okay, so we've talked about ICE administrative warrants, we've talked about federal warrants, federal court warrants. Now we're going to talk about subpoenas. The first type of subpoena we're going to talk about is an administrative subpoena. So just like the ICE administrative warrant, this document is not issued from a court. It just requests the production of documents or other evidence, and it is issued by an immigration officer. It will typically contain certain fields of information like a file number, a subpoena number, mailing address, the regulations that apply, stuff like that. If you get an administrative subpoena, if you ever see one, they typically don't require immediate compliance. So as with the federal court warrant, what you want to do is contact your designated legal counsel and let them know about the receipt of the subpoena, and then they can choose how to proceed, including whether or not to challenge an administrative subpoena in court before a judge. Like the ICE administrative warrant, this ICE administrative or other administrative subpoena is not a court order that would permit the LEA or the school under FERPA to disclose educational records for a student without consent of a parent or guardian or eligible 18-year-old plus student. So it follows then that disclosure of information protected by FERPA in response to administrative subpoena could violate FERPA. And so you should typically be receiving written consent from the appropriate person within the family, the parent, guardian, eligible student, before turning over any student records. Okay. Just like there's federal warrants, there are also federal judicial subpoenas, and that's a document that requests production of documents or other evidence. It identifies certain fields, just like the other type of subpoena we talked about. And again, local educational agencies generally do not need to comply immediately with the subpoena, and they can choose how to proceed after consulting with legal counsel and can potentially challenge it in immigration or before a U.S. district court. So just like everything else, if you get it, consult with legal counsel, follow your general instructions. Last thing we're going to talk about is the fact that there could be court orders. If you get a court order, then you should review the court order and consult with legal counsel and proceed accordingly. Okay, policy recommendations. So we talked about how schools should generally be providing safe and secure and peaceful learning environments for all students. And related to that, some school districts have chose to adopt what have been termed like safe haven policies for students or families. School districts can also define safe or sensitive locations to include schools, all official activities of the school, including those occurring in public places and other adjacent areas, so not just on school campus. All of the property, whether owned, controlled, or leased. And schools should seek commitments from those who may be working with them under contract or other service providers not to facilitate immigration enforcement at any of the safe or sensitive locations that the school or the board has identified unless they're required to do so by law. And I know that many schools do this because, again, I've been present in them. The schools should have a policy for receiving visitors onto campus and for monitoring once they do so. In my experience, a lot of times that looks like checking in at the front office, signing in, getting like a visitor's badge. Sometimes you're escorted to where you need to go, or the person that you've asked to speak with may be called down to the office. Whatever it is, there should be a policy, it should be known, and it should generally be followed. So we're not treating anybody special, we're treating everybody the same with regard to how they are treated once they arrive on campus. There should be a policy for responding to immigration officers' presence on campus, and it should be known and it should be followed. And when that happens, if it happens, you should know who you tell. Do you tell the superintendent? Has your school district designated another person who's not the superintendent that is your appropriate contact on something like this? Who were you supposed to direct immigration enforcement personnel to? Is that a specific person? Who's going to tell your legal counsel? How is that going to work? And if, whenever this happens, if this happens, an immigration enforcement officer shows up on campus, you need to tell us, please. And you can email bcj at doj.ca.gov. And this is also in our, again, handy dandy guidance, references it. To let us know about an attempt by immigration enforcement to gain access to a school site for immigration purposes. Another big takeaway, ICE administrative warrant don't permit any law enforcement officer to search any area he or she could not enter as a member of the public. So, somebody can always ask for your consent. Is it okay if I? But they're not entitled to it. You don't have to give consent, and they're not otherwise entitled to force it. So it follows that without exigent circumstances, i.e. an emergency, or a judicial warrant, one signed by a district court judge or a magistrate, school staff, LEA personnel, are not required to give an immigration enforcement officer permission or consent to enter a non-public area to conduct a search of any kind. Okay. And then we want to have trainings, right? So just like we want to have policies and we want them to be known, we want to be updating everybody. We want to train everybody. And I know that there's always lots of trainings on lots of topics, and we want everyone to be refreshed on everything, but this stuff is really important. So I'm hopeful that you guys have already engaged in many conversations at your school sites about these types of issues, just to have a plan in place to know what your policies are. But if you haven't, maybe go and poke somebody when you get back and say, hey, we got to do this. Okay, so this is about responding to the detention or deportation of a student's family member. You know, that can be a very traumatic or triggering experience for students. And in this climate, in this day, it's not necessarily a hypothetical that will never come to pass. So I don't know, it's been a while since I've been in school, but when I was, we had the yellow emergency cards. I don't know if they're still yellow. Are they still yellow? No. Whatever color they are do they still exist in hard copy? Yeah, they're not just virtual now. So it's important that we have a completed emergency card for every student. And that we are encouraging families to keep it updated. And if you are a teacher, not because just of this, just make it a periodic practice to remind people, hey, if your emergency card information has changed, you get a new cell number, whatever, let us know. We want that information to be updated for every student. So if something happens and we need to get in contact with somebody, we should follow the information that's on that emergency card that the parent or guardian has set out. And we shouldn't be contacting, and I'm sure this is known, but I'll say it anyway, Child Protective Services, unless the school is unsuccessful in arranging for care for a child through the emergency contact information that you have on that card or that you've otherwise received from the parent or legal guardian. Okay, so policy recommendations. We want to encourage families to have safety plans. What would happen if, so that the family has thought about it and they have something that can be put into place that is known by the parents and the children and whoever the appropriate adult is that they are going to have designated. The plan should and may identify a trusted adult to care for the student if a parent or guardian becomes unable to do so. And the student should know who that trusted adult is and how to reach them. So two types of documents, I should say, I'm going to flag for you are the caregiver's authorization affidavit. The CAA, you guys are probably all aware of, it can be used by a certain group of family members to enroll a student in school and to make certain medical decisions. It does not provide legal custody. It's a limited authorization. And then I'm also going to just flag that sometimes families have taken a step further, particularly if the trusted adult that they've identified is not a family member who couldn't use that caregiver's authorization affidavit, to actually engage in filling out a petition and associated paperwork for a temporary guardianship. And so that's something that certain families may do, and they may have that paperwork all ready to go so that it can be filed if something happens. Immigration is certainly an area in which families can do this, but it is not the only area in which certain families have found a need to sort of have a backup plan in place. Again, the most important thing is that we want to encourage families to have talked about it. We want the students to know what's going to happen to them or who the appropriate trusted adult is in case circumstances arise where that becomes necessary. Okay. Couple of additional things, particularly for you guys. There is an ICE detainee locator that is just generally used that becomes helpful to families if you're trying to find someone. They're supposed to be at X place and they're not. How do we check if they're in custody? That's one way. You should never, and I mean never, refer to families to ICE or other immigration enforcement. And then, again, legal assistance, right? Encourage families who may benefit or need this to interact with a legal provider, whether in private practice or certain accredited organizations or a nonprofit that may be able to provide representation, whether that's in removal defense or seeking affirmative immigration relief or guidance or legal advice to the family. And then the last piece is that consulates or embassies from the native country can also be very helpful and provide information or additional assistance. Okay, this is my last big legal point. And again, in this climate, we've seen not just with potentially discrimination based on national origin or immigration status, but on a variety of other protected characteristics, sort of an increase in bullying or harassment or intimidation or discrimination. So again, our governing law, state law, California requires each local educational agency to have a policy prohibiting discrimination, harassment, intimidation, and bullying based on actual or perceived certain protected characteristics like nationality, ethnicity, or immigration status. So you should have a policy, you should know what it prohibits. So we want also to be notifying families about students' rights to a free public education regardless of immigration status. Sometimes that might be accompanied by a Know Your Rights, like information or booklet. And then we want to publicize our anti-discrimination, anti-harassment, anti-intimidation, anti-bullying policies. And we want families to know how they can file a complaint if a problem arises. And then we, and by we I mean you all, should know what happens to that complaint. What do you do with it? What happens? How does it go? When will we decide? Etc. So again, we want families to know there's a policy, what to do if they feel like the policy may have been violated or not followed, and then what's going to happen if they do complain. What is that process? Okay. Again, these are in the handouts that have been provided for this training. There is a quick reference for school officials. I would suggest, and I'm sure you all do, have like a bulletin board or a spot where you keep important papers. This is 4 pages, 2 if you double-side it and staple it. Keep it somewhere where you have it handy, just on the off chance that something comes up and you need to know what to do if there are any, what happens if someone shows up in your classroom? What are you going to do? Well, take a breath, reach for your handout, and provide some information. And then we have guides for students and families that are 2 pages that school districts can use. They're available in these languages that we've on our website, as is all of these handouts. And if probably all of your school districts have already sent something like this home to all of your student and families at the beginning of the school year, or periodically, or whenever you do it. But if you haven't, again, maybe poke somebody, say, hey, is this something that we should be sharing with our families whenever we disseminate information? Just as like a heads up, quick reference guide, know what to do, right? Information is power, particularly in these types of sensitive areas. Any questions? Just giving you a lot of legalese at 9 a.m. on a Friday, on the 3rd day of your conference, probably after you sat in traffic for a while. I know I did. Questions about any of this stuff? Okay. This is me. So, like I talked to you guys about how you all can encourage families to make complaints and know what happens to them. Our office also regularly receives complaints from members of the public for any number of reasons. Thing to keep in mind is that we don't typically get involved in individual cases or individual matters. Like I said, we're doing civil, systemic, policy and practices, big investigations, but you can always feel free to submit a complaint to our office. Our website isn't like super amazing and flashy, but it does have good information. And, put it on your rotation of sites maybe you check out regularly, not your daily rotation, but maybe your like once quarterly rotation to see what's happening. All of our guidance on this topic specifically is on the BCJ website, which would just be at oag.ca.gov/BCJ. The link to the complaint is also there. And, schools are often very good at aggregating resources for families, and I just ask that either your own policies or our policy guidance are among those that get aggregated for those families in this time. So, I don't have anything else for you. I want to thank you very much for coming to this piece. Again, I know it was sort of esoteric and dense and legal, and I hope that you have a great rest of your Friday and a good rest of your conference.
Thank you.